joined by Susan de Wet from our third-party claims department. Thanks for joining us, Susan.
Thank you for having me.
So yeah, I think most of our listeners and viewers are aware of a third-party claim that one can institute after a motor vehicle accident. But maybe you can just in principle explain, when can you claim, etc.?
The Section 17 of the Road Accident Fund Act actually stipulates perfectly well within the parameters who can claim and who cannot. So, for instance, I'm just going to, out of memory, cite the Act. I hope I can remember everything. So, Section 17 stipulates that the fund must compensate any person for damages or loss caused by an accident due to negligent driving or wrongful act of a driver.
So it's related to a motor vehicle
Yes.
accident. In other words, someone driving a motor vehicle. That's one of
a
the
motor vehicle
important requirements,
any
obviously.
place in the Republic of South Africa. Yes. So anyone that suffers damage, injuries, or loss of support, loss of income can claim. But you must prove wrongfulness and negligence on the side of the other driver.
Okay. And how is this third-party fund, the road accident fund, financed? One often hears or sees in the news that it's insolvent, that there's not enough money. So where do they get their money from?
I must say the RAF did struggle during COVID because the RAF's funding comes from the fuel levy. It's currently R2.18 per litre for petrol and diesel. And the RAF gets compensated for every litre that gets sold. So during COVID, there was people didn't travel as much. So the RAF had some issues apart from the other issues that we know of, misspending and so forth.
But the insolvency as such is then actually not such a big problem because there's a constant income as people buy petrol and diesel.
Yes.
And the levy is paid over to the RAF. Okay, but let's maybe get to the case that we actually wanted to discuss today. Maybe you can first give us the facts.
Okay, so the facts, this is a very interesting case for me. The facts are as follows. So the accident occurred on the 21st of June 2014. And the deceased at the time he only sustained orthopedic injuries. The claim was lodged by his attorneys against RAF. They issued summons. They sent him to medico-legal experts, orthopedic surgeon, occupational therapist, and a clinical psychologist. But unfortunately, in December 2016, he committed suicide. So that was 2.5 years after the accident. Thereafter, his family, his wife, lodged a claim for loss of support for her and the minor children. So that claim was instituted, summons was issued, and so forth. Then what happened further was that the plaintiff had to, now the deceased wife, she's the plaintiff, she had to prove on a balance of probabilities that his suicide is a direct cause of the injuries he sustained in that accident in 2014.
You mentioned earlier that you have a third-party claim if the loss results from the driving of a motor vehicle.
Yes.
So obviously it could now be argued that the driving of the motor vehicle didn't cause his death. It was what happened in between, the suicide.
Yes. That there was a new intervening act.
Yes.
Yes.
Okay.
So the court also had to look at the question. Was there a nexus, a legal nexus between the suicide and the injuries he sustained? So did the injuries cause a psychological condition or psychiatric condition that caused him to commit suicide?
Okay. And the outcome, I'm sure everybody's very curious to know. So did the court find that they could claim? So was it not too far away from the motor vehicle accident, or did they say no, the suicide came in between, so there is no claim?
Unfortunately, the court found that there is no, they cannot claim. The plaintiff, which is now the wife, could not prove the nexus between the suicide and the injuries. The evidence wasn't enough. So to give you an example, she testified, she was very honest, to be true. She testified that he never suffered from depression, never, not even before the accident or after the accident. His mother also testified. She had a very close relationship with him. And she also testified that she never saw any signs of depression. the wife also admitted during her testimony that they had an argument the morning of his suicide. That's also a clear indication that there could be an intervening event. Or
Okay.
novus actus interveniens.
Yes, the Latin phrase.
Yes.
So I think we referred to causation, whether there's that nexus that you referred to, causation between the act as such and the loss that was suffered, or was there something that happened in between that actually meant that there is no
Was there
close
break?
enough
Yes.
causation between what initially happened and the loss that was suffered? So maybe you can give us other examples of where people were not able to prove causation, or were maybe able to prove causation as such. In other words, the link is close enough or not.
Yes, I actually have 2 Supreme Court of Appeal cases. The first where they could prove the causation. It's a RAF case. Coincidentally, it's RAF, the RAF versus Russell, where the evidence was clear enough that the deceased did not suffer from depression before the accident, and the brain injury sustained in this accident clearly caused the condition. This is depression that caused his suicide.
Okay.
To give an example, his wife found him on the roof of his house one day, and he was admitted into a psychiatric hospital, and after that he committed suicide.
So it's actually a similar set of facts, but in this
Very
case,
similar.
the court said no. There's enough evidence that it's actually the motor vehicle accident that caused the depression, that caused the suicide consequently, and therefore they were successful.
Yes.
So yeah, depends on the facts, as we now mentioned.
And
So
the
you
evidence.
could actually succeed with such a claim.
You
So if
could.
the motor vehicle accident leads to a suicide, you can prove that it's close enough, then you will succeed.
Correct.
Okay.
So the second case is State versus Mokgeti. In this case, a bank robber shot a bank teller through his spine. He was paraplegic after the incident. He subsequently recovered from his injuries. He returned back to work 6 months after the incident. He passed away due to septicemia. The evidence before the court was that he was told by his doctors that he needs to shift his position, and he needs the correct cushioning in his wheelchair to prevent pressure sores from forming, and he did not adhere to his doctor's advice, and due to that he got pressure sores and subsequently passed away.
Okay.
So the court said there's no causal connection between the incident and the death. So the bank robbers were not guilty of murder, just attempted.
Interesting, yeah.
Yes.
So he should have limited his damages by doing what needs to be done to stabilize, make sure that he doesn't pass away, etc. Okay, I think that clarifies this interesting court case. So thank you, Susan, and thank you for listening and watching.